So I went back and checked. I'm like, oh, the license plate's expired. Let me double check on this. And I sent it off to the commander. They came by and found out it was a stolen vehicle from Bedford that somebody dumped there.
Oh, jeez. Wow. Okay, why
The
is
vacant
this
properties seem to attract it.
All right, let me see if I can pull those up. Why is this not streaming? Is this 3985 East 66th?
6507 Lansing.
Oh, okay. Let's see.
I just resent.
That was.
Oh, you did?
The board has notes on the agenda that it's been rescheduled, that Lansing's been rescheduled to February 16th, 2022. HJD Enterprises, that was would have been the first one on the docket.
Yeah.
Yeah, there's notes that it's been rescheduled for February 16th, 2022. So they must have asked for a continuance. Is that the only one you have, Councilman?
Thanks for pointing that out. I didn't even see that little asterisk at the bottom.
Yeah, it's at the bottom of the agenda.
Yeah.
February 16th, 2022.
Yeah. You have any other ones, Councilman?
Let me flip through.
Because there were quite a few continuances, but I don't see you on any.
Yeah, that was the only one I
Okay.
had. So who has the application for the appeal?
You'll have to get that from Carmela. She's the record holder.
All right, I'll get it from Carmela.
Okay.
I'll try and reach out. I mean, this is another out-of-town owner bought the property, I guess, just because of how pretty the front of the building looks.
I'm sure if you shoot her an email, she can send you that. It's public record. But
okay.
She's the record keeper.
All right.
Good to see you. Take care.
All right. See you later. Take care.
Good to see you.
Can't do it.
I forgot to put it on.
No, you're good, Joe. We can hear you.
We
Hello?
can't see you though. What-
Okay, turn your video on.
Turn, I don't have a space.
Down the bottom
for
of the
it.
screen, if it's not there, tap the screen and it
I
should
wish I
show
had, yeah.
start the video.
Sign in, don't have an account. No, it doesn't say that anywhere.
Did he tap the screen?
I can put the sound on.
Tap the screen to bring up what you do on the bottom there.
Yeah, I did.
You tap the screen? Okay.
Yep,
Does it show it?
it's not coming. I've got it on the phone too.
Well, okay, that may be a problem. You gotta have it just on this laptop.
Oh, there you go. Thank you.
I don't know.
You might
How-
have to
how do I-
scroll down. If you don't have the full screen, you might have to scroll down to the bottom to see this start video.
Yeah, right. So when I got it,
Good morning. If you're on the phone, please mute yourself until you're asked to speak. Thank you. Until your case is called.
Oh, we can do it.
What's happening?
I can't get it on.
Wait. I'll wait.
We are joining. It's connecting again.
So as long as we can hear you and you can hear us, that's all that's required.
All I have to do is hit the video.
Okay.
Okay? So
No video.
he's good to go. He knows. He's just trying to find it on there.
Auto and video.
Got audio, okay.
Mr. Chairman, he may have his control bar minimized. That there's a little arrow in the middle of the control bar where you can minimize it and maximize it. I don't know if that's technically what's going on with his device, but I'm not going to object. Since you have four
He
members,
can
I'm not
hear-
going to object if he's just heard, as long as we can continually hear him if he's there.
Okay. All right, he can keep looking around with that. Carmella?
I like to sit down. Yeah, I like to sit down.
Just
And Maurice, I'm guessing he's caller user 3 is what it sounds like, who's not muted, is what it sounds like.
Yes, I just muted him.
Give me 1 second, please.
Okay.
Hello, can you hear me?
Yes.
There we go. There we go. Now take it easy. Is that at 8 a.m.? 9 a.m. It's the pre-meeting link. Now, there you go. That's the meeting link. Stay everything away. Join as a guest. It says to join as a guest.
You're already in, Joe.
There we go. We got it. We got it.
You're gonna have echoes in there. Joe, you've got 2 devices going.
What is it? Okay, there we go.
Joe,
Yes.
you're gonna have to turn, you have 2 devices on and you're getting an echo. So you're gonna have to turn your phone off, I believe. Which one are you getting the video on? Oh, don't, lost you all together here. There you are. Okay. All right. Did you turn off your phone? Stop it from WebEx. Okay. You sound good now.
Unmute. It's the.
Okay, let's mute up until we get started here. Carmela's going to be back on here in a minute.
Okay, I'm ready.
Okay, Cleveland Board of Building Standards and Appeals is now in session in compliance with notification requirements of Ohio's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976. Notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Call-in users can unmute by using *6. All meeting activity is being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak in a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comment on a particular matter. Ms. Aston?
Thank you, Mr. Chairman. As it relates to this hearing, the city would ask to verify that it was being currently live streamed.
And it is.
Thank you, Maurice. And then, as we always do, pursuant to the rules posted at the Ohio Supreme Court, start of the pandemic, the city does object to the chat function. Reason being, this would not occur if we were actually meeting in room 514. Thank you, Mr. Chairman.
Ms. Davis, we have a quorum?
Yes, we have a quorum.
Okay, we'll call the first docket.
Call the roll.
Oh, I'm sorry. I
Did you
didn't
call the roll?
I didn't
Yes.
call the roll.
We will, yes, let's call the roll.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher,
Yes.
Mr. Dink.
Yes.
We have a quorum.
Okay, so I guess we're aware that the first docket has been rescheduled. So we're moving on to docket A77-21, 14127 Rainbow Avenue.
Application and fees are in order. Notice of violations of condemnation of the main structure issued on August 11, 2021. Appeal statement received September 10th, 2021, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. With the appellant for docket A77-21, please state your name for the record.
Attorney Nathan Zion here. I'm counsel for the appellant. He's on the line. Maybe he's muted right now.
Just a reminder to anyone that's actually on the telephone, if you hit *6 on your telephone, you will be unmuted. *6.
This is Ramsey McGalley.
Okay, McGalley. All right.
This is Danny Boris. I'm the property manager.
Okay. Is there anyone else?
No, Mr. Chairman.
Okay. That's it?
Yes.
Okay. Solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Preliminarily, Mr. Chairman, Patricia McGinty Aston for the City of Cleveland Law Department. Just to briefly state, in the appeal statements, appellant's attorney argues in number 8 that the abatement by the city would result in a taking without just compensation. The law is clear. This is any abatement pursuant to public safety is not a taking. It is an abatement of a public nuisance, and there's case law to that effect. And that taking argument, perhaps he's merely preserving it, but as a constitutional argument, it's not proper before this board, but it's also wouldn't be right because the property is still standing. I'm just preserving the record. Thank you, Mr. Chairman.
Okay. Okay, who's going to speak for the docket?
Your Honor, or Mr. Chairman, I apologize. Danny Boris is the property manager who has managed this property here. I have Ramsey on the line simply because he is the property owner, but Danny has the knowledge about what's been going on at the property.
Okay, Danny got on, right?
Yes.
Okay, go ahead.
So the situation is that we actually own half of a duplex. Through the years, we tried to buy the other side, but we were unable due to the fact that the owner of the other side passed away. So we actually had to just fix our side. We fixed the property. We had a tenant there with a Section 8 voucher. And it turned out that this tenant basically destroyed the whole house. We tried multiple times to contact Section 8 regarding illegal activity that was happening at the house. We filed a signal with the Cleveland Police Department to have car going by the house every night. And unfortunately, we ended up having our house completely destroyed. And at the moment, we can't basically do anything. We cannot demolish the house our side because it's a duplex and we don't have the legal right because we don't own the other side. So we are in a situation where we don't want to fix it, we want to demolish it, but we don't have the right to do so.
Okay. And I guess ownership is split on this also?
Yes, the 14125 is owned by another person, and 14127 is owned by Ramsey Magali.
Okay. All right, let's go over to Mr. Vanover.
Can you hear me?
Yes.
Well, I mean, it's a condemnation of the main structure. I don't have the ownership deed in front of me, but my question to the appellant, Mr. Chairman, is how many parcels does this sit on?
Ms. Boris?
I'm sorry, what did you ask me?
How many parcels are on this property?
It's 2 parcels. It's 14125 Rainbow and 14127 Rainbow Avenue.
And these,
Mr. Chairman, counsel for Ramsey, if I could clarify here.
Yes.
So the appellant owns 1 parcel and half of the duplex resides on that parcel. The other adjacent unit resides on a separate tax parcel that is currently in foreclosure. As noted in the appeal, it's under case CV 20-938-290. It's supposedly owned by Miss Diane Baker, who has since passed away, and there are unknown heirs. So the foreclosure action is trying to seek who owns the other half of that duplex.
Mr. Chairman, to council, since you raised the foreclosure matter, if I may, they're using that as the basis, and I understand why they are arguing to this board that they cannot abate the nuisance because they've chosen demolition. But through Mr. Chairman, to counsel for appellant, has your client or you interceded or filed any sort of intervention into that foreclosure matter since the rights of your client's property are being affected by that? And you've raised that before this board as a basis?
Not currently. We've reached out to the prosecuting attorney, and we intend to intercede to determine, what actions we might take from there on. We're hoping we have an interested party who's interested in purchasing the entire duplex, but obviously with the unknown owners on the other side, we are unable to, accommodate that. But we're trying to enter into that case to work with them to sell the whole entity, the whole house, if possible.
But you haven't yet. But your client intends to.
That's correct.
Thank you.
Yes.
That's what I was wondering. Thank you, Mr.
Yes.
Yeah, Mr. Vanover.
So, Mr. Chairman, our position is this. The decision to co-own a duplex on separate parcels was, that was a financial business decision that was made, when this half of this property was purchased. It is not impossible to raise half of a side-by-side duplex, and that's what this is. It's a side-by-side duplex where the portion in question is, according to the Cuyahoga County Auditor, it sits wholly on its own parcel. So the goal, a plan to sell this structure to somebody else is not a plan to abate the nuisance, but to just discard the liability. So we ask that you uphold the notice of violation, and the owner has the appellate has the right to make the repairs to abate the nuisance on the portion of the property they own, or they can abate by demolition, and it's possible to, it can be done. We do it, unfortunately, we're charged all the time with doing it throughout the city.
Mr. Chairman, for the appellant.
Yes.
We have reached out to and gotten quotes from a few contractors, and our intention is to demolish if possible. So my client is working on that direction. Our sole intent is not to just sell this property off to a third party so that we can wipe our hands and be done with it. That was just simply raised with the notion that, you know, we're trying to work to get the problem fixed. But we are looking to demolish it. And have gotten some quotes, but we need more time. And that's really the request, as stated in the appeal, is just that we have adequate time to do that, to protect our rights against any would-be owners, those unknown heirs that we, you know, don't know where they are, who they are, what claims they might have if something goes wrong with the demolition.
How much time are you looking for?
That's a great question, Mr. Chairman. With the with the proceedings and the foreclosure kind of being dragged down, the last docket entry was August. You know, we were hoping for 6 months, 180 days. I don't know if that's you know, acceptable to county. I will note the house is boarded up, and the squatters, there have been several squatters. They have all been removed, and so, you know, to the extent that it was a safety issue, you know, it should be protected against. So I don't think 6 months is an unreasonable time frame for an extension of time.
Mr. Vanover.
Well, Mr. Chairman, according to, so just briefly, you're saying the neighboring property is 14125?
That's
is
correct.
The address of that structure?
Yes, that's correct.
Okay, so then, yeah, so our record shows that structure is also condemned, and the property is boarded up because, you know, the city boarded it up. So 180 days, although for a repair plan, we wouldn't object to 180 days, Mr. Chairman, but this looks like it's 180 days to determine what's happening with the other owners. I'm a little concerned that that's not really a plan to abate the nuisance, and that ties our hands for further deterioration. Our expectation, of course, with any property that one owns, that you know, it's maintained, it's boarded, and you know, the trash is at least cleaned up out of the yard. You know, these are recent photographs. I'm assuming, Mr. Chairman, I actually have a question for the appellate. Is the adjacent property is vacant as well?
Yes, the
Yes,
other property is vacant too.
Right. So, yeah, Mr. Chairman, I mean, I'm a little concerned that 180 days is waiting for a disposition that's not going to happen. And
Okay.
any ruling from this board, we would require that the trash and debris around the structure be remediated immediately.
Mr. Chairman, that was going to be my issue, is we could take steps in that, you know, in that vein pretty quickly, get that done, you know, immediately. And 180 days would permit us opportunity, as counsel for the city indicated, that we could enter, you know, the foreclosure, seek out any claims that might be there, and work with in that proceeding to demolish the structure. So we could do kind of we could bifurcate this into a quick, prompt cleanup, but then also 180 days extension to demolish.
So, Mr. Vanover, we're looking at maybe 30 days to clean this thing, get it cleaned up good. Does that seem reasonable?
So, Mr. Chairman, we would ask that the resolution be 180 days to completely abate the violations.
Okay. All right.
Mr. Chairman, may I say something?
Yes.
As far as the statement Mr. Vanover made regarding the other side, when we purchased the property back in 2017, that was done through the sheriff's office on an auction, and we wanted to purchase the other side. However, there were no measurements taken about the other side since then, and the other side, 14125, actually was put for condemnation back in 2018. I did multiple calls to the sheriff's office, to the Cleveland, City of Cleveland, also called the land bank multiple times through the years in attempts to buy the other side. And every time I was told that we are not able to buy it, that we have to wait. The other side is like almost already falling apart. That's the problem. The other side, if you see photos, we have photos. The back of the side is fallen, the whole walls are off. So we tried to actually buy the whole duplex for 4 years, and we were not allowed to.
Okay, Ms. Boris, I understand what you're saying. What's kind of in front of us here, though, is just your property and your parcel. That's what's charged, and so we're going to give you the time. Go ahead.
I apologize.
Yeah, Mr. Vanna.
If I may respond quickly and then bring up a point. With the city, the city doesn't, we don't have the authority to sell somebody else's property. So that's, unless the land bank owns it or, or the city entity owns it, we don't have the authority to just sell somebody else's property that they still own. I will also point out that remanding this property to the Department of Building and Housing, we will proceed along our administrative path, which gives us the authority to raise the structure, both sides of the structure under our condemnation powers, which appears to be where this appellant is going anyhow.
Okay, that's a good point.
And we would bid that out to 3 bidders, and I mean, I'm not going to opine on cost differences or things of that nature. And then the cost recovery goes to the owner, or both owners, of the property. So
that might be a better solution. Right. Yeah, I'm thinking. The other board members, do you have any comments on this, on whether we should remand this property? No comment.
I think this should be remanded and they should work with the city.
Right, because of the 2 properties there, I think it's a good idea, and both of them are condemned, so makes a lot more sense. So we, we find, of course, that the violations do exist, and so we're going to get a motion to remand the property to the Division of City Housing for any further action to be taken. Is there a motion?
So move.
Okay, a motion by
Second.
Mr. Bradley. Okay.
Second.
Second. All right, second by
Mr.
Mr.
Maskey?
Maskey.
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher,
Yes.
Mr. Dink.
Yes.
Okay, yeah, you'll be getting a notification within 2 weeks. Thank you.
Thank you, Mr. Chairman.
Thank you.
Okay, next docket, 8021 3440 Trent Avenue.
Application and fees are in order. Notice of violation is interior and exterior maintenance issued August 16, 2021. Appeal statement received September 15, 2021, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. With the appellant and council representation for docket A 8021, please state your name for the record.
So this is George Lang.
I'm sorry, could you repeat your name, please?
This is George Lang.
And is there anyone for council in Ward 14 here to speak on behalf of docket A 8021?
Okay.
Mr. Chairman, briefly, the appeal statement appears, Mr. Lang, do you have counsel? Is Andrew Weiner an attorney for you?
No, they're not present.
Okay, it is an attorney though, correct?
Sorry, who is an attorney?
It is the person listed on your appeal statement, Andrew Weiner, an attorney?
No, he's the property manager.
Thank you. I just wanted to clarify that we weren't expecting somebody else such as the attorney. Thank you, Mr. Chairman.
Okay, so we do have the owner. We're going to swear you in, solemnly swear to tell the truth, the whole truth, so help you God?
Yes, I do.
Okay, Mr. Lang, go ahead and give us what your plans are.
Yes, so I submitted these photos that are being shared on the screen here to show the previous condition. I do have a contract with a general contractor who's actively working on the property. So we continue to, with the rehab, there are some after photos in this deck too, I believe, to show some of the progress that we've made. This is a 4-unit property and we are going through unit by unit to rehabilitate.
Okay. How much time are you looking for?
Also hard to say for me. We've been going at this slower than I anticipated. It's been about 2 months or so of active work from the general contractor. I would say at this pace, another 6 months to complete the last 3 units.
Okay, let me go over to Mr. Vanover.
Mr. Chairman of the appellate, is the property empty at this time?
Property is empty, yes.
All right, so Mr. Chairman, there are permits. There's a building permit and electrical permit for the structure. We don't object to more time, with the understanding that the property is vacant and will remain so until the violations are abated.
Okay, sounds good. So a motion to take it to June 10th, which would be 6 months to abate underneath those conditions stated by Mr. Vanover, that it remains unoccupied until it is taken care of. So motion to give
Mr. Chairman, sorry to interrupt. I have a question for Mr.
Sure.
Mr. Vanover.
Yes.
Is there a way that we can rent out unit by unit as they become ready?
That would be, so you would get approval from your building inspector on your permit, who is, so it's assigned to Chief Gergich, so I don't know what inspector has been assigned, but yes, there is a path where you can get partial occupancy on the units as you complete them, providing that there are no serious hazards in the other units.
Understood.
Okay.
Could I track down who I need to speak with to get that?
It's on your permit. The general contractor has a, on the permit, there's an inspector name. And then there'll be an inspector that's on, on the property doing the inspections. So you could call the number on the permit, or typically your general contractor will, as the units become available and the violations are corrected.
Okay, that answer the question? Okay, motion for 6 months to June 10th, 2022 to abate violations, and that it will be allowed to, as units meet the requirements, can be occupied as per the inspector.
So
motion.
moved.
Okay, so moved,
Second.
Mr. Maskey. Second by Mr. Denk.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher,
Yes.
Mr. Dink.
Yes.
Okay. In 2 weeks, you'll be notified. So we got docket A, 8121, 2128 West 55th Street.
Application and fees are in order. Notice of violation is condemnation of the main structure, issued on August 27, 2021. Appellant requesting time to abate the violation. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton, Law. With the appellant for docket A, 8121, please state your names for the record.
This is Patty. I have, not on this property, but I have interacted with both Mr. Abu Hashim and his counsel, Sam Zingali. I was hoping they were one of the call-in users. If they are, they're still muted. If they are not, because they have a counsel on here, and like I said, I've had interactions on other properties with both of them, in enforcement actions. If we don't get hold of them, I'm going to ask that you continue this. I will reach out to Mr. Zingali regarding this matter, but he always represents Mr. Abu Hashim on this, and nobody's unmuting, so I'm going to presume they're not present.
We'll go ahead and have the docket continued then.
Thank you, Mr. Chairman, because they always appear on everything at every hearing. So I will reach out to Mr. Zingali.
Okay. Okay, we'll move on. Next docket, A5721, 10732 Bel Air Road.
Application and fees are in order. Notice of violation is exterior maintenance and condemnation of the garage. Issued on July 12, 2021. Appeal statement received August 12, 2021, requesting for time to abate the violation. This docket was originally heard on October 27th, where the owner failed to appear, but the tenant had stepped in to represent for the owner without an authorized letter from the owner to do so. It was rescheduled to November 10th, where the owner still failed to appear, and the tenant again appeared on behalf of the owner without authorization to do so. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. With the owner for docket A 5721, please state your name for the record.
Hello again. My name is Daniel Nolan. I'm the tenant. I'm here because the owner, Frank, could not appear, and I have had trouble. We've had trouble, both of us, getting together to try to get at least a letter to give me authority to speak. All I can ask at this time is to, if you know,
Hold on, sir. Hold on.
Sorry.
I've got to swear you in if they're going to
Right,
decide to hear it. Thank you.
Right, yeah, we're just looking for a name at that point, but yes, solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay, Mr. Nolan, so you have stated already, you don't really have any paperwork that shows that you can speak for the owner, I'm assuming.
He misunderstood. He thought it was a form that you guys provided that we had to submit. Then I guess he found out it's just a letter we have to submit. And he's been traveling a lot. I've been sick and doing some traveling and dealing with my sister's health. And so we've had trouble hooking up.
Okay, I'm going to go back to Miss Aston on.
Well, Mr. Chairman, to the tenant, do both of you have email? If so, he could email you something, and then you could forward it on to Ms.
But doesn't it have to be notarized? That would mean we have to both appear with somebody.
A letter. No, I don't know where a letter. The board receives letter of authority all the time. I would defer to the board and its counsel, but we see on non-notarized letters all the time. I mean,
oh, okay.
We're not going to object to an email that he sends to you that you forward to Ms. Davis.
Oh, okay. Because I thought.
So, well, I can't help your misunderstanding. Mr. Chairman, if you want to go ahead and hear it, and if you give him one last chance, and if he does not have it at that time, we'll ask that you uphold, deny, and remand.
I can definitely get something through email if that's all that's required.
That his misunderstanding is his own misunderstanding. It was clearly stated previously, but we wouldn't object to an email being sent and forwarded, but with the understanding, if it does not come at the next time, this has been months now.
Right,
I understand. Going to ask that you deny it and remand it.
Okay, all right. So I know you've been continuing on and doing some work there. So Mr. Nolan, tell us what we got going on here.
Well, the yard is the exterior maintenance stuff in the yard is pretty much all done. There's just a couple things that have to get moved, and that should happen today or tomorrow, as long as I can get some help. And the garage, I think he said he's been talking to some contractors to pull a permit. So that's all I know until I can talk with him. I want to meet with him in person instead of phone and email stuff, So he said he talked to, I think, HCI and another contractor. I forget the name. Some guys from out east.
All right, let's go over to Mr. Vanover.
Well, Mr. Chairman, this is the concern with things of this nature is that we've got a tenant who is appeared again for the third time for a violation notice that is 5 months old. And the response is that he thinks the owner talked to somebody.
Oh, he did state that in
Okay.
a text message, but you know, until I see somebody here myself, I can't vouch for more than that. You know, but he doesn't lie to me. We have a hard time hooking up. You know.
Go ahead,
Secretary
Mr.
to the
Vanover.
Chairman,
What was that?
Mr. Chairman,
Yes.
just for the record, not only did I email the owner, I've also called him and left him a message to contact the office in regards to the letter that would need to be submitted to give his tenant authority to represent him in today's hearing. I contacted him before November 10th hearing, as well as before November 24th hearing, and I always send out another courtesy email the day before the hearing to let them know the status and what needs to be provided for anyone outside of themselves to speak on behalf of them.
Maybe he forwarded me the email, but maybe I didn't see anything in it like that. I don't know.
All right, what we're looking at is a lot of miscommunication back and forth, and there's been plenty of time to have done something, but I don't know. I'm gonna
Mr.
check
Chairman, I mean, the miscommunication is clearly not on the board's side, as Ms. Davis stated. The miscommunication appears to be intentional on
agree.
behalf of the owner at this point.
Not
Not even
between
Mr.,
them.
not the tenant who's been diligent to come here, but
Right.
that weighs
Because
heavily.
I'm involved in trying to mitigate this stuff, and I don't have a problem.
This
I mean,
isn't,
I know
well,
that's not your.
the ownership resides with the owner, and
Yes.
as diligent as you may have been, if Ms. Davis's statements are that the board is continually contacting the owner, and there appears to be willful, it's not miscommunication. He's
listen,
ignoring that, and that this board needs to, sir, I'm just going to complete this. The board needs to look at that and weigh that pretty heavily about this whole, he's going to get a letter or even an email.
Well,
We
what we're gonna
would
do.
defer to this board, but I think it's pretty clear what's going on.
Okay, so Mr. Vanover, this looks like it might be one of these cases where it may need to be remanded in order to resolve it.
Well,
I don't know what you're.
I agree. I think that, there's a lot of talk about miscommunication and all of this. The reality is, you see the condition of the garage. This is a disinterested owner who hasn't taken the violation notice seriously, and I haven't heard any testimony when the last time the owner was actually at the property that he owned. So we would ask, in all of this time, conversation was that the nuisance have been, sir, let me finish. If the conversation we're having is that the nuisances have been abated, then it would be a different conversation. The reality, that's just not true. So we would ask that you deny any more time. You remand it back to the Department of Building and Housing, find that it was properly issued. The owner can still do his job as the owner of the property, and it allows the city to do our job as well.
Yeah, I think will get the owner's attention and get him moving. So everything will still go through, Mr. Nolan. It's not like, oh, this is the end of the world. It's just a matter of, we can't keep coming back over this, and we don't have the person that's in charge to make the decision.
I understand.
Okay, so we're going to remand it. I'm going to talk to the board members here, and that'll get things moving. Okay, that'll help you out too, because I know you've been working on stuff. So I'm going to ask the board make a motion to remand this, find that it has been properly notified, and to go ahead and remand the property back to the city for any further.
So moved.
Okay, so we got a motion by Mr. Dank, motion by Mr. Bradley, second by Mr. Bradley.
Mr. Maschke?
Yes.
Mr. Bradley?
Yes.
Mr. Gallagher?
Yes.
Mr. Dank?
Yes.
Yes. Okay. All right. So there'll be in 2 weeks, there'll be a notice of this sent out, and good luck.
Thank you.
Okay, thank you. Okay, see our next Next docket is A 67214540 Grayton Road.
Application and fees are in order. Notice of violation is a fire vacate and a condemnation of the main structure. Issued on July 29th, 2021. Appeal statement received August 29th, 2021. Requested for time to abate the violation. We first heard this docket on November 10th. It was asked for continuance. It was continued to November 24th and now continued to today. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. With the appellate for docket A 6721, please state your name for the record.
This is Christopher Knack. I'm the son of Nancy Manning, who I also have on the phone. Mom, please state your name.
Nancy Manning.
Okay. Okay, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
I do.
Yes.
Yeah.
Okay.
Yes.
Okay, so who's going to be speaking here?
I think I would start with a statement, and you can, ask my mother whatever you'd like. But
Okay.
The state of the project has been in July. There was a criminal arson fire at my mom's home, and we do have full insurance on the property. However, the time to get a contractor committed and aligned with the insurance company has taken longer than expected, and so we did have the notice since then. And even we were prepared to share this in November. We have a verbal agreement with a fire restoration contractor in Cleveland, but they've been working with the insurance company to get approval on their estimate of the damage. And that's Bentley Fire Restoration in Cleveland, Ohio. So the project is positioned to move fully forward with restoring the home, and they plan to pull a permit once the insurance company verifies their estimate for the scope of work. So,
Okay.
Mr. Chairman, if I may, since Patricia McGinty asked on behalf of the city, sir, Mr. Chairman, to the appellant's son, Christopher, you stated there's insurance. Has the insurance settled on the amount under the policy?
they did the initial claim filing, and they've processed that, and the mortgage company is holding those funds. And they also paid out for my mother's personal property. However,
Okay.
the contractor looking to do the work is seeking, a broader scope because they believe it was underestimated and they can't complete the work. So the insurance company is responding, acknowledges the insurance, but I believe there's a pending proposal from the contractor in progress with the insurance company at this point.
So, Mr. Chairman, the state and local law, there is a fire insurance proceeds. I do not know if I can't get a clear statement of whether or not the first step is they come to an agreement. There's a calculation by statute. There's an agreed amount that is settled upon. If that is not done, sometimes there has to be litigation, but then by statute, state and local law, a certain portion of that goes to the city for under the proceeds. So that is then held in a separate fire insurance proceeds fund by legislative design, et cetera, et cetera. So there is insurance, and a portion of that would come to the city in case the city has to take abatement action that covers the city's cost. But I would defer to Mr. Vanover. Sir, what is your insurance company's name for this property?
Ohio Fair Plan, and they've already executed one settlement level, which is being held by the mortgage company and their lost claims, which I'm sure they would, provide whatever proceeds are necessary.
Ohio what plan?
Ohio Fair Plan is the insurance underwriter.
Thank you.
Okay, Mr. Vanover?
Mr. Chairman, the appellate, who is your contractor?
Bentley Fire Restoration.
Bentley?
Bentley, yes.
Okay. Where are they located?
I believe his personal address is in Olmsted Falls, but he works in that area, and he was appeared to be familiar with Mr. Davis, who's been our building inspector.
Okay. So, Mr. Chairman,
I don't have his card in front of me.
we don't object to more time for the restoration. There is a running motif where these negotiations with insurance companies are taking considerably longer than they have in the past. We would ask we would ask for no more than 90 days for the permits to be pulled for the project, and then 180 days to correct to abate the violations.
Okay. All
on the
right,
property.
that sounds reasonable. Okay, so motion is in order to have the permits acquired by March 1st, 2022, and to complete the abatement, the violations by June 10th, 2022. Motion?
So move.
Okay, motion by Mr. Bradley.
Second.
Second by Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher,
Yes.
Mr. Dink.
Yes.
Okay.
Mr. Chairman, to the appellate, real quick, once you receive your resolution from the board ordering you to get these things done, you're going to want to copy that and send it to your insurance company.
Okay, and do I need to
It puts
provide
them
them
on
information
notice.
for this fire escrow account?
Yeah, you'll also remind them that that is a requirement because, but what that does is it puts them on notice that there's a ticking clock.
Okay.
And that they have a responsibility everybody has a responsibility to do something.
Okay, I will contact the underwriter today.
Very good. Okay, thank you, Mr. Manning.
Thank you.
Okay, we'll move on to the next docket. Docket A 7521, 7518, Rutledge Avenue.
Application and fees are in order. Notice of violation is interior and exterior maintenance, issued July 1st, 2021. Appeal statement received August 25th, 2021, requesting for time to abate the violation. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. With the appellate for docket A 7521, please state your name for the record.
I see her list, I see Ms. Gartland listed, but then she's muted.
Oh. *6 if you're on a cell phone, right?
You are right. It doesn't look like she's on a cell phone, though.
Okay, Ms. Gartland, you have to unmute for us to hear you. Tap your screen and look for the unmute button.
It's at the bottom of the screen.
Do
I
we know
cannot
if she's
unmute
even
her.
at her computer?
We don't know that.
Chairman, can we move to the next case and see if she's back on after?
Yes, I think that's a good idea. She might have left the screen for a moment. Okay, let's see. Let's go on to docket A 7921, 3243 West 32nd Street. Ms. Davis?
Sorry.
I believe that was Christopher Mulvaney. He was on earlier, or Mulvaney.
Okay.
Yes, you, Chris.
Well, we have to hear from Ms. Davis anyways. We opened docket 87921.
We moved on to 79.
Yeah, we moved on because we're not getting a response from Ms. Gartland.
Okay. Docket A7921, application and fees are in order. Notice of violations of interior and exterior maintenance. Issue August 11, 2021. Appeal statement received August 30th, 2021, requesting for time to abate the violation. Present for the hearing, Tom Vanover, Building and Housing. Patricia Aston Law. With the representation for docket A7921, please state your name for the record.
Christopher Mulvaney, counsel for KTC Properties.
Okay, Mr. Mulvaney, will you solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay. Go ahead and proceed.
Thank you. My client received the notice of violation, is seeking an extension of time to make the repairs. It is a rental property. It is occupied by tenants. An eviction has been filed and judgment was granted for restitution. However, the bailiffs will not be able to effect a put out until January. So we request 90 days extension to permit my client time to get possession of the property back and make the necessary repairs.
Okay, how long after the 90 days would you need to make the repairs? What are you looking at?
I believe the repairs will be able to be finished within 90 days.
Okay. Okay. Mr. Vanover?
No objection.
No objection. Okay, so motion to give the appellant till March 1st, 2022 to get the people out, and then until June 10th, 2022 to abate the violations. Motion so in order?
Moved.
Okay, Mr. Maschke, motion.
Second.
Okay, second by Mr. Bradley.
Mr. Maschke,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher,
Yes.
Mr. Dink.
Yes.
Okay, notice will be sent out within 2 weeks of the property. Thank you.
Thank you very much, sir.
Okay, so we've got docket A 8321 14421 Coit Road. Is it Coit? I'm sorry, Coit Road.
Application and fees are in order. This is a condemnation of the main structure issued on September 16, 2021. Appeal statement received September 20th, 2021, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing. Patricia Ashton Law. With the appellant for docket A 8321, please state your name for the record. There is no appellant present, and the appellant was properly notified.
Mr. Chairman, briefly, Carmela, is this the one you told me the owner contacted you that they had already demolished that one?
No, the owner hasn't contacted me from the permits and the inspector's report.
Oh, I
But they did
misunderstood.
have-
Okay.
Okay.
I totally wrote down the wrong thing. That's on me. So Mr. Chairman, if I may, to Ms. Davis, you sent out notice of today's public hearing, and no notice was returned to you. Is that correct?
That is correct.
And have you received any email, phone call, or voicemail, or fax, or any communication from this appellant regarding this matter?
No.
Okay, thank you. So, Mr. Chairman, it appears that in docket A8321, notice was properly served, as Ms. Davis stated, and you can go ahead. You have sent due process right to be heard, and you can proceed on this matter. Thank you.
Okay, has anyone just joined for the docket 8321? I seen somebody just come on. Give you a second to respond. I mean, from the pictures, it appears
that might be her. It says guest. Ma'am, are you Lola?
I think that is Ms. Garland.
Oh, you think, okay, you think,
This is,
Okay, we got an echoing situation here. You got, I think, two devices. We're gonna have to mute one. We're not sure who that is, right? Okay, so we're gonna proceed on, and it appears like as if it has been raised and cleaned. We're gonna get Mr. Vanover on to see what he knows about it.
Mr. Chairman, there was a permit issued for the demolition of the structure that
Please mute, yes. Thank you.
there was
Okay,
a permit issued that was inspected as compliance final on December 2nd, 2021. So the nuisance has been abated, and our record shows that the notice of violation has been closed.
Okay. So, any further action? Do we need to give them a
Mr.
date?
Chairman and Mr. Vanover, was it done at the city, or as Ms. Davis indicated, the owner pulled the permit and demolished it and took care of the nuisance? Because if it was the owner who did it, the board can give them through today for just as they would usually do for the abatement of it. If it was the city, we would ask that you uphold deny remand. So it depends on who.
Our records indicate that it was a private demolition.
So, Mr. Chairman, it appears the owner did, as Ms. Davis indicated, the owner pulled the permit. You could probably give them through today and give them time through today since it was done through the permit process. Thank you.
Okay. So we'll give them till, let's see, December 9th until to abate the violation. The motion.
So move.
Okay, motion by Mr.
Second.
Bradley.
Second.
Okay, second by Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher,
Yes.
Mr. Dane.
yes. Say yes.
Hello?
Mr. Dane. We need a
Say
yes.
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 Okay, very good. All right. Okay, it is what it is. All right, so we'll move on to docket 8421, 3824 West 36th Street.
Cut it in half.
Application and fees are in
I
order.
was listening.
Notice of
I heard.
violation is a no permit and interior and exterior maintenance issued on September 9th, 2021. Appeal statement received September 29th,
Got this right
2021,
down
requesting
here.
for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. With the appellant for docket A 8421, please state your name for the record.
If you're on the telephone, please hit *6 to unmute yourself.
It doesn't appear that the appellant is here today.
Okay.
They have
Mr.
been properly notified.
Thank you. Mr. Chairman, to Ms. Davis, you sent out your notice for today's public hearing, and there it also indicates an email on the appeal statement. Did any of your notice or information get returned back to the board's file for any reason whatsoever?
No.
And did you receive any email, phone call, voicemail, et cetera, from anyone regarding this docket?
No.
Thank you, Mr. Chairman. It appears notice having been properly sent and no information having been returned to the board, you have the proper due process notification, met the proper due process notification requirements and could proceed.
Okay, Mr. Vanover.
Mr. Chairman, I mean, we would ask that you deny any more time and remand it back. This is a rental property.
I better swear everybody in first, right?
Yeah, you
I'm
should.
sorry. Okay. Solemnly swear to tell the truth, told the truth, self you got.
I do.
Okay, go ahead, Mr. Vanwiller.
Yeah, so Mr. Chairman, this is a rental property. It's also a rental property that is, you know, it's owned by a corporation. So, or an LLC or an LPC. So we would ask that you deny any more time, remand it back to the Department of Building and Housing so that we can follow up.
Okay, we'll do just that. We'll remand the property back to you for any further action to be done and deny any time at this point. Motion.
So move.
Mr.
Second.
Bradley. Mr. Dank.
Say it. Say it. Say it.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher,
Yes.
Mr. Dank.
Yes.
Okay. I guess we're going back up. I see that Ms. Gartland has rejoined. So let's go back up and open up docket A7521.
Application fees
Go
are
ahead.
in order.
Go ahead.
Okay.
Notice of violations, interior and exterior maintenance issued on July 1st, 2021. Appeal statement received August 25th, 2021, requesting for time to make the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton, Law. With the appellate for docket A7521, please state your name for the record.
Beverly Gartland.
Okay. Is anyone else going to give anything on this particular case?
I'm sorry. I'm getting some feedback.
Did you have two devices open?
My telephone. Do you want me to turn my telephone off? My cell phone?
Yes.
Okay.
We have Heather Lazar from Councilwoman Spencer's office also on the line. I'm not sure if she wants to give testimony or is she just here for observation.
Okay. Let's go ahead and let's swear everybody in and then we'll move on from there. Okay, solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Okay. Okay. All right. Who's
You
going to
need to
give?
turn your cell phone off.
I did
that-
turn it off.
Yeah, you have to turn off one of your devices. I think you have two on. And,
I just turned my cell phone off. I have my tablet on.
we're going to have to go with one device or the other, I think.
Yeah, Maureen, is she logged in twice?
Right.
Let me hold you up for just.
I don't see her logged in twice, no.
She's not. Why
And
is
the
it up
other
for you?
call-in user is muted, so I don't know where the echo's coming from.
I may have logged in twice because it took me off. And then I went back and logged in.
Oh, I do see, yeah, your guest and Beverly Gartland. All right,
Okay.
so let me, here, hold on a minute. I'm going to try to move one to the lobby.
I'm sorry.
And it's still doing it.
Is it? I think, can you
Nope.
hear me?
Oh, there you go, that was it.
That's
That's
better.
good.
That was it.
Okay, Ms. Lazar, do you want to speak in the beginning or wait?
I'm Beverly Gartland.
Right, but I'm asking, I guess we have Heather Lazar from Ward 15. You are on the line for this case?
No.
Good morning, Mr. Chairman. Yes, I am. And I defer to Ms. Gartland to speak first.
Okay, very good. Okay, go ahead, Ms. Garland.
Okay, what I'm doing is requesting some extra time to get the outside maintenance done. The inside is completed. The roof is fixed, and I have some pictures that I can show you of the inside of the house.
Okay.
So let's see, I hit share, or maybe I should go to, let me go get them and then I'll do that.
Mr. Chairman, we don't have sharing enabled on this meeting.
Okay.
We generally don't have people.
Okay. All right, so you would have had to send them in ahead of time. Okay. So we're not going to be able to see the pictures inside, but I don't know if there were any permits required for this work or not. So I'm going to, first I'm going to ask you, how much more time do you think you need to abate the violations?
Well, I would like to add, because of weather for the outside, I would like to ask for at least a month because we need no rain and dampness.
For how long was that?
Well, I'm thinking perhaps a month.
A month to complete the violations for the
Right.
outside.
But part of that's going to depend on the weather.
Okay.
And the availability of the people to fix it.
Okay. All right. Let me go over to Mr. Vanover and see what he knows about this.
Mr. Chairman, to the appellant, this is a rental property, correct?
Yes.
Is it currently occupied?
I'm not sure. I'm not taking care of it as much now. I was in an automobile accident about 4 or 5 years ago, and I'm having problems. And I'm getting older, so I need to step back a little.
Mr. Chairman, to the appellant, Ms. Garland, do you have a property manager for this property?
I get help from my son sometimes, yes.
Well, we have any more questions, Mr. Vanover?
Yeah, I mean, that makes a difference. We don't object to more time. But this is even though it's privately owned as opposed to corporately owned, this is an investment property. And so we don't object to 90 days to abate the nuisance. To get there are interior and exterior issues. It sounds like a lot of the interior issues may have been corrected, but I don't have those photos. So, Mr. Chairman, we don't object to 90 days to make those corrections, but I will offer the warning. This is, it's an investment property that needs to be maintained. And, if it's too much, it's too much. It should be, we don't want to be back here after granting time for these issues, for other issues.
No, we won't be.
Okay, let's hear from Ward 15 representative.
Thank you, Mr. Chairman. The council office is adamantly opposed to any extension in time. The fact that repairs were made, these repairs included electrical wiring and smoke detectors that were not present. We would ask that certainly those be inspected by Building and Housing. Also, I don't quite understand how a rental registration could be issued in September when there were such violations against the property issued by Building and Housing, and these included health and safety issues. So we are not in favor of any time, and the request that Ms. Garland is making for a month to allow for moisture issues, we're in the winter months, so there will be moisture. And 1 month is highly unrealistic if that is what she is requesting.
Well, I know that Mr. Vanover said that we could go with 90 days, which would, because I'm looking at the pictures and I'm saying 1 month, and then getting somebody to do it, and then with the weather, yeah, absolutely, that wouldn't be doable. No question about that. Mr. Vanover, you want to respond to Ms. Lazar?
Well, Mr. Chairman, I know no. I mean, if there's a need to understand the rental registration process and why and how properties are registered, and what the purpose, the difference between the rental inspection and the registration, I am more than willing to do that with council office, but we can do that offline. So we want to see the property corrected and a reasonable amount of time to do that. I do agree, this is a rental property. It should have never gotten to this condition. It should have been, maintained along the way. And inspecting corrections made on violations, that's what the Department of Building and Housing does. So we will be inspecting and have been, inspecting the corrections that are made. So I'm more than willing to talk about any of those things with council office online. But the reality is, if the property is remanded back to the Department of Building and Housing, we will, we'll do progress inspections to verify that the work is getting completed, because that's ultimately the expectation.
Mr. Chairman?
Yes.
Mr. Chairman, to Mr. Vanover, were there any permits pulled for any of the work done on this property?
It doesn't appear that there were.
Okay. I'm concerned. I'm hearing that there's electrical and smoke detector work without any oversight. If the appellant states that it's only going to take a month to do the work, and it takes us 2 weeks to issue our notice, I would like to support Ward 15 and remand the project back to the city, which will then help the appellant get this work done in 30 days. And if it's a 2-week gap, then the city can work with the appellant. And if the appellant can't get the work completed, then the city will have the authority to remedy the situation appropriately.
Yeah, Ms. Garland,
Yes.
I think that you're going to need more time than that, which is making.
Yes, I think so also. And with regard to some of the things that were noted, for instance, there weren't any holes in the floor. I don't know what the problem was when they went in, but they're registers, and someone must have taken the what do you call that? The thing off that you put
Right.
over the register.
Right.
And we put them back on. There was no problem there at all. There aren't holes. That's the only thing that.
Was there electrical work done?
No, what it was that there were some regular cords, like you'd take it from an outlet and put it to a light, something.
I'm seeing that. Okay.
A regular one, not one that's a regular light that you have to plug in, a lamp.
All right.
It wasn't.
Is it possible to bring the violation notice up on the screen? Because there are no electrical issues noted in the notice of violation. It's excessive use of extension cords. Exterior window units need to be fixed. So exterior window units are boarded up. The smoke detector is not installed on each story of the dwelling structure. These would not be hardwired smoke detectors. These would be based on the age of the building. These can be and would have been battery powered smoke detectors, but that are required. And then there's some exterior siding is loose, broken, deteriorated, or missing. And then the baseboards in the bathroom are deteriorated and missing.
Okay, so I'm concerned too about the amount of time that the chief feels is necessary, and I think it may be better served if we remand it back to the city so that you can monitor this progress. So it doesn't stop you from getting someone, Ms. Garland, to go ahead and continue and fix these problems. Not a problem. I just think it'd be better to remand it to make sure that you're getting enough time to do all this.
Okay. So,
okay.
Well, should
So
I request then 90 days? Is that okay?
well, it's what we're going to do is remand it in whatever time, basically, that the city perceives is necessary to.
Mr. Chairman,
go ahead.
If I may interject here, that's not accurate. Okay, the city.
Okay.
The notice of violation, the compliance date was 7/31/2021. So at this point, she is out of compliance, and the city has a responsibility to, and you know, rule as you wish, but the city has a responsibility once out of compliance to proceed along our administrative, you know, process, which, you know, could up to and including criminal prosecution for a
do I need to get a
misdemeanor. So this is we will continue to work, but understand that if the board gives time, then she's granted time. If the board remands it, then the expectation is that we would, you know, evaluate the situation, but we have a responsibility to proceed, and that could include criminal prosecution of the owner
Mr.
of
Chairman,
this property.
if Mr. Vanover indicated he did not object to 90 days. So the city's position is stated that did not believe 90 days would be unreasonable.
Well,
Mr. Chairman,
hold on.
Mr. Chairman.
Yes.
This work should have been done in the end of July of this year. It's almost 6 months, 5 months later. I think this work should be remanded. I'm concerned the appellant is representing this project, but says she doesn't know much about it. She's relying on her son to manage it. We've not seen or heard from her son. I would support that we remand the property back to building and housing.
May I say?
Go ahead, Ms. Garland.
A lot of that all on the inside has been completed, and some on the outside has as well. One problem that arose was that I didn't get the notification because the mail wasn't coming, and I had changed my residence address. And I didn't get anything until it was, I don't have that in front of me now, but I had talked with Ms. Davis about that. And then this is the first, this is the first time I was asked to come to a meeting. So this, I mean, this isn't.
Mr. Gallagher, that's not an excuse for poor behavior on how to manage your property. Ma'am, I live in this neighborhood, and it's deplorable that I have to drive by homes of people that own property that don't live in my neighborhood, that let them go into disrepair. Mr. Gallagher, I'd like you to call the question.
I would really like you to see the inside of the house before we do things like this, because we are making the repairs. This just isn't right.
I hear what you're saying, Ms. Garland, but I think, you know, looking at even with the outside in order to, you know, how much time is going to be necessary, I think that we would be better served if we did remand this particular project. Because again, it's a rental property. It should have never got into this repair, you know, as Mr. Vanover pointed out. So I'm going to refer to others on the board and see what their opinion is. Okay.
Mr. Chairman, I
Yes.
tried to turn on sharing. If you want to have her, if you want to have her try to share those pictures, if that's helpful, we can try that.
I would ask that
It's
you
up to
do
you.
so because she does have the right to
Yes.
present that, and with
Oh,
this
absolutely.
technological
I agree.
age,
I
she
realize
does
they
have,
should have
she would
been
have
sent
walked
ahead
in.
of time. But
I understand that, but due process requires us to allow her to do that. And yes, the rules and probably stated that she has to send them in. But if we were meeting in person in room 515, she would hand them to the board as per normal process. And she has that due process right to present her case. I would encourage the board to allow her to do so.
I'll allow her to do it if she can do it. Can you do it?
Well, I can do it when I use Zoom, but I don't know. Now, here's what happened again. I don't know if it's
There's-
because it's time. Please, just a minute. I don't know if this is just time or what's happening, but now my computer has gone to different modes and I don't see you. So I don't want to lose you again, and I'm not sure how to do that.
Okay.
You see the screen, ma'am? Can you see the current? Can you see our screen?
No,
I can see the screen.
The current screen I can see is
Okay,
just.
so ma'am, if you just listen to me for a second.
Okay.
If you look at the bottom of the screen, you'll see that there is a screenshot, a picture of what the bottom of your screen should look like. And you'll see that there is a share button down there.
Okay, right, but I don't have that showing right now. What it did was it went back to my regular computer mode for for what it's showing.
Okay.
And
All
so
right.
that isn't there.
Yeah.
Maurice, can Ms. Gartland email the photos?
Yes, I can.
Absolutely.
And then
Sure.
someone at City Hall can post them?
Yes.
Because I would like to see the dining room. That is where the holes in the floor were reported by Building and Housing. So I'm hoping to
Sure.
see a photo of the dining room floor.
Yeah.
You have to, if you have Carmela Davis's email address, you can go ahead and send them to her, and we can get her to display them, or she can then forward them to me. But
okay, yes,
Mr. Chairman,
Yes.
Ms. Gartland has been notified several times on how to submit photos
Okay.
on her behalf. If we're having issues today and before the resolution is adopted, and you see fit to reopen this document, so her evidence can be shown, and we can do that at the next hearing. If I cannot receive it, she can't send the documents today, but the instructions are outlined in the appeal when they receive their notice, as well as before their hearing date. I'll also reiterate a deadline for all picture evidence to submit it to the board to be presented in today's hearing.
All right. And you've gone over this with Ms. Gartland on how to do all this before. Is that correct?
Her, as well as all other appellants that have submitted picture evidence today.
Yeah. What I'm asking is that you did that for Ms. Gartland prior to let her know how to do this.
Yes.
Okay. All right. I'm going to ask the other board members, what's your thoughts on the time issue? Whether you think we should remand it or should we give time? Do you want to weigh in on that, Mr. Bradley, Mr. Dank?
Yes, I think we should remand it to the city.
Mr. Dank?
What do you think? Remand it or give time? Oh, no.
Mr. Dank? You got Mr. Mash?
Hello?
Yes.
Remand it. Remand it.
Remand it.
Okay, so we got the other three board members are saying that we should remand this, and you still proceed. I mean, it's.
I'm concerned. I'm very concerned when you say criminal charges, and Do I need to get a lawyer? I mean, the stuff inside, if you could see the inside, I didn't think I had to send pictures in, that it would be done also on the computer.
Well, I think the concern right now is the outside and getting that done in the time that has elapsed between anything being done and now. I think that's, and this again is a rental property. And that's the reason
But
why,
there's been so much rain.
well, it's
I
since
know,
September.
I am not an unintelligent person, okay? I am not trying to do anything here. I'm trying to get this resolved. My own house, I haven't been able to get some repairs done on the outside because of rain. And then the workers are so overloaded, it's hard to get someone to do something. And my neighbor was saying the same thing about his house. It's been very difficult.
Oh, I understand. I understand it's not easy.
I'm trying.
Yeah, I understand what you're saying. I'm just not sure that you understand all that has to be done here, you know, and even suggesting that 1 month could do it. So that's why I think it should be remanded back in order to properly, you still get your contractor, you still get this thing done in a reasonable amount of time.
Well, if we went with 90 days, I mean.
Mr. Chairman, can you make the motion, please?
Well, you guys make the motion. It's already been recommended.
I'll make the motion. The violation was issued in accordance, and we uphold it. And I motion that we remand the property to building and housing.
Is there a second?
Second.
Second. Call the roll.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher,
Yes.
Mr. Dink.
Yes.
Okay, so it's been remanded, and you will be given a notification within 2 weeks, okay, of the decision of the board. And you just work with the city. Okay?
Thank you. Do I need to get an attorney or anything?
Well, that's up to you. I just think you need to get the
Mr.
work
Chairman,
done.
if I may, on
Yes.
behalf of the city law department, that is wholly within her discretion. If she chooses to get an attorney and see what her rights are, that is her absolute right to do so. We can't advise you one way. The board, ma'am, the board and the city cannot advise you one way or the other, but you always have that right.
There you go.
Thank you.
Okay. All right.
Thank you, Mr. Chairman.
Do I leave the meeting now?
Yeah, you will receive notification by mail.
Okay, but now can I leave the meeting?
Yes, you can. Thank you.
Thank you very much.
Okay. All right, is that the last that we have? No, we have, that's the last case, right? Okay, so we have
Yes, the
approval
last
of
docket
resolution.
has been rescheduled.
What's that?
Yes, the last docket has been rescheduled.
The last docket has to be rescheduled, correct? Okay, we don't have to do that, it's gonna be done, right?
That's correct.
Okay, very good. So we need approval of resolutions, A62, 21, A63, 21, A64, 21, 65, 21, A68, 21, A70, 21, A71, 21, A73, 21. All those in order?
So moved.
That's correct.
Okay, so moved by Mr. Maskey, second.
Second.
Second by Mr. Bradley.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher,
Yes.
Mr. Dink.
Yes.
Approval of minutes for November 10th, 2021. Are there any additions or corrections?
No.
Okay.
Motion for approval is submitted.
Okay.
Second.
Okay. Moved and seconded. Maskey and Mr. Dank.
Mr. Maskey,
Yes.
Mr. Gallagher,
Yes.
Mr. Bradley,
Yes.
Mr. Dink.
Yes.
Okay, there's no other official business. The meeting is now adjourned.
And our, the 18th, our luncheon,
What's that?
the luncheon is on the 18th.
For which one now?
Are we adjourned?
Yes,
Okay.
meeting is
Thank
over.